Assalamualaikum warahmatullahi wabarakatuh. Today we're gonna present the topic of Hibah Amanah, analysis of application and challenges. The presenter is Iman binti Aminuddin, Nur Sazrin binti Hamran, Iman Nur Sabina binti Ibrahim.
The definitions of Hibah Amanah. Hibah Amanah, a form of conditional hibah, can be defined as an agreement for the gift of a donor's asset during his or her lifetime for the benefit of the beneficiary without any considerations. The gift, however, will only be effective upon the death of the donor, and the donor is, in most cases, still allowed to benefit from the asset during his lifetime. The donor's asset will be entrusted to be appointed trustee to be held for the benefit of beneficiary after the donor's death. So this is application of Hibah Amanah. Many major players are introducing Hibah Amanah into their portfolio, such as Amanah Raya have their own portfolio, Amanah Saham Nasional Berhad, Tabung Haji, Bank Islam and other have Hibah Amanah. So this is basically the concept of Hibah Amanah. This example from the ASSB. Mana ada pemegang unit, pemegang amanah dan penerima amanah. Antara pemegang unit dan pemegang amanah perlu adakan sirah dan surat ikatan hibah serta akad hibah. Antara pemegang amanah dengan penerima amanah hanya perlu ada akad hibah. So semasa fasa hidup, pemberi hibah melaksanakan akad hibah, pemberian dan penerimaan harta dengan penerima dengan kehadiran dua saksi. Kemudian pemberi hibah dan penerima hibah bersetuju untuk melantik ASP atau apa saja trustee sebagai pemegang amanah bagi mentadbir harta selepas kematian. Jadi apabila berlaku selepas kematian, ASP akan mengagihkan harta hibah kepada penerima seperti yang telah dimeterai dalam surat ikatan amanah. So this is application Hibah Amanah in Tabung Haji. So Tabung Haji with more than 50-year experience in an institution responsible for the welfare and management of the country's Haji pilgrim, as well as a series of the Islamic fund. These institutions are considered reliable by Malaysian society and are trusted for their expertise, and their decision will significantly impact the economy of the country and the interest of the Ummah. So the application process of Hibah Amanah Tabung Haji has three depositor, tabung haji and recipient. So the depositor will fill in borang permohonan hibah amanah tabung haji and the power of attorney POA, and will make a payment for the application fee and then receive one original copy of Hibah Amanah Tabung Haji Deeds of Trust and POA. So the tabung haji will revise, process and register deed of trust POA of Hibah Amanah Tabung Haji at High Court, and then submit notification for the confirmation letter of Hibah Amanah TH to depositor. So the recipient fill in borang permohonan Hibah Amanah TH as a beneficiary. Dan ini adalah hibah di amanah raya, di mana amanah raya ada dua yang boleh dibuat di amanah raya, antaranya adalah hibah amanah raya. Kedua, deklarasi hibah amanah raya. Apa itu? Okay, kalau hibah amanah raya seperti biasa adalah kontrak atau pemberian milik, iaitu aset tanpa balasan oleh penghibah kepada penerima hibah. Jadi amanah raya dilantik sebagai pemegang amanah kepada harta hibah untuk satu tempoh tertentu berdasarkan surat ikatan hibah. Dan surat ikatan amanah. Surat ikatan hibah adalah surat ikatan amanah antara penghibah dan penerima hibah, manakala surat ikatan amanah adalah antara penerima hibah dan amanah raya. Kemudian deklarasi hibah pula adalah penyataan bertulis yang menjelaskan kedudukan harta yang telah dihibahkan kepada penerima hibah semasa hayat penghibah. Jadi seorang penghibah itu akan dilantik sebagai pemegang amanah utama aset yang dihibahkan, dan amanah raya pula akan dilantik sebagai pemegang amanah gantian bagi pihak pemegang amanah utama apabila penghibah meninggal dunia.
Assalamualaikum warahmatullahi wabarakatuh. My name is Amanah Sabrina. So, I will talk about the benefit of the trust hibah. So, the first benefit is the welfare of the trust hibah grantor can be maintained, as it is because the grantor of trust hibah still have the power to control or use the property of hibah as long as he is still alive. The second benefit is it was to protect the interests of the trust hibah recipients, especially young children. In Islam, the trust hibah was formed for the benefit for those who are still minor and have not yet attained the age of majority, or those who are mentally incapable. By law, they are not able to manage the property. So, their family members will be the trustee and be responsible to manage the assets until they attain the age of majority by law. The third benefit is to protect the interests of the hibah grantor's property. The asset will be given to the trust hibah recipient when the grantor died. And the fourth is the trust hibah also show the effort to overcome the issue of lengthy process in well estate planning among Muslims, as it is no longer a part of the estate of the deceased, which is subjected to the Muslim law of administration of estate.
Okay, the first challenge of trust hibah is fairness and justice. Okay, bagaimana sebenarnya hibah amanah ni menjadi cabaran untuk keadilan dan keadilan dalam pembahagian harta, disebabkan hibah trust produk ni hampir sama dengan conventional living trust, which mean benefactor dia diberi kebebasan yang tinggi untuk mengagihkan harta dia boleh sahaja tanpa mengambil kira consideration berkenaan dengan faraid. So, concern yang utama berkenaan dengan hibah amanah ni apabila hibah amanah ni dia membenarkan donor mendapat complete control, kawalan penuh terhadap pembagi harta selepas dia meninggal dunia. So dalam masa yang sama, Central Bank of Malaysia pun tak ada mengeluarkan lagi apa-apa comprehensive guideline berkenaan dengan hibah amanah. So benda ni akan memberi risiko seseorang itu mengagihkan harta tanpa adil lah. So unfair preferential treatment is generally prohibited in Islam. Mengikut hadis daripada Amir yang ketika mana sahabat Rasulullah, sahabat Nabi berjumpa Nabi mengatakan bahawa beliau telah mengagihkan hadiah kepada anak lelakinya sahaja. Jadi Nabi SAW berkata kepada sahabat ini, takutlah Allah dan kembalikan semula hadiah yang diberikan kepada anak lelakinya sahaja. Maksudnya Nabi SAW merintahkan agar harta itu walaupun ia adalah hibah, ia mesti dibahagikan dengan adil untuk kesemua warisnya. The second challenge is conflict of jurisdiction. This mean pertembungan bidang kuasa. Okay, walaupun hibah ni sebenarnya diletakkan di bawah undang-undang syariah jurisdiction, but the same cannot be said to hibah trust. Sebab hibah trust ni adalah hybrid. Di antara hibah dan trust adalah gabungan antara hibah dan amanah. So kalau amanah, dia terpakai di bawah the Malaysia Trust Act, yang mana ia terpakai di bawah Mahkamah Sivil. Jadi bila mana ada gabungan antara hibah dan amanah, berlaku persoalan mahkamah manakah yang lebih berhak untuk mendengar persoalan hibah amanah. So kalau kita lihat kepada artikel 121 dan perenggan pertama perenggan pertama senarai kedua jadual ke-9, memang jelaslah mengatakan hal-hal yang berkenaan dengan Islamic law perlu diasingkan di bawah mahkamah syariah. If the case is being moved to the civil court, the application of Islamic law in civil courts may create a problem of interpretation of Islamic law since the absence of any aspect of Islamic law on the bench. So boleh saja mahkamah memutuskan tanpa mengambil kira berkenaan dengan faraid, wasiat, tanpa mengambil kira keadilan setiap waris. Dan jika if the case is brought to the Syariah court, it is still open to interpretation whether the Syariah court will consider the interest of the legal heirs under faraid distribution. Sebabkan oleh mahkamah syariah ni tidak mempunyai bidang kuasa dalam pembahagian harta pusaka. But similar situation occur in the previous cases where the persons nominated in EPF, tabung haji and other cooperative societies have been regarded as trustee by the National Fatwa Committee in 1970. So bila dia regarded as trustee, maksudnya ia di bawah mahkamah sivil juga. Contoh kes Wan Naimah versus Wan Muhammad Nawawi, the court applied the civil law on trust and not Islamic trust law to implement an oral gift involving a Muslim family. Ini masalah, ini risiko yang disebut tadi apabila kes ini dibawa kepada mahkamah sivil, which mean dalam kes Wan Naimah versus Wan Muhammad Nawawi, mahkamah pakai civil law dan mengetepikan Islamic law dalam mengimplementasi oral gift hibah yang berkait dengan Muslim family. Okay, manakala dalam kes TM Faraza Khan and others versus Mira Hussain, TM Muhammad Muhyiddin, yang mana mahkamah memutuskan the law, undang-undang yang akan mentadbir amanah di Malaysia ini adalah undang-undang sivil, walaupun dia adalah Muslim ataupun non-Muslim. So itu yang berlaku di Malaysia. The third one is hibah amanah not yet to be governed by any statutory provision. Where yang pertama, hibah amanah ni dia adalah satu instrumen yang tak ada apa-apa statut. Seperti hibah dalam takaful. Yang mana hibah dalam takaful ni dilindungi di bawah Seksyen 142 Senarai Jadual ke-10 Islamic Financial Service Act Akta Kewangan Islam 2013. Okay, yang kedua, the only permissibility on the hibah contract is based on resolution made by the Federal Territory Sharia Committee. Maksudnya berkenaan dengan hibah amanah kontrak ni hanya berdasarkan dengan fatwa kebangsaan pada fatwa kebangsaan yang ke-56. Okey, yang ketiga, the component of hibah provided in the BNM policy paper is generally in nature and cater in hibah in general. Maksudnya, dekat BNM hanya menjelaskan tentang komponen hibah secara umum, tetapi tidak pun memberikan satu spesifikasi guideline terhadap hibah amanah. Yang mana hibah amanah ni adalah satu bentuk baru gabungan produk di antara hibah dan amanah. So, sepatutnya BNM memberikan satu guideline yang jelas untuk describe hibah amanah ataupun memberi polisi dokumen berkenaan dengan hibah amanah. Okay. Next one is hibah amanah is the borderline of trust law and Islamic inheritance law. So hibah amanah ni dia di tengah-tengah antara undang-undang amanah dan juga undang-undang pewarisan Islam. So oleh itu dia ada satu possibility yang tinggi yang mana law trust undang-undang amanah akan terpakai dalam banyak senario walaupun namanya adalah hibah amanah. Walaupun terdapat nama hibah, tapi undang-undang amanah akan diguna pakai. Jadi benda ni akan membentuk satu gap dalam undang-undang lah. The suggestion is naming the beneficiaries, which may in the spirit of protecting the interests of the eligible heirs under Faraid and preventing the donor from channeling his assets to anyone else based on his own interests. So naming of the beneficiaries of Hibah Trust shall follow closely the Faraid and Wasiyah rules. Although the donor is free to distribute his property during his lifetime using direct hibah in the event of terminal ill or writing a will. Naming the beneficiaries of hibah trust shall follow the following rules. First one is two-thirds, which means the portion must be received by the beneficiaries who are considered as the legal heirs under Faraid, distributed in accordance to the Faraid rules. Rather than expressly stating the name of the legal heir, a general clause shall be included as follows, such as two-thirds of my properties will go to those who will be considered as legal heir under Faraid upon my death. This is the example. So this is the way to avoid the hibah assets from becoming idle if the named heir died before distribution of assets being executed. It's also to avoid assets being distributed to only one or particular group or legal heirs only while depriving other eligible heirs. So the first one is two-thirds and the second one is one-third, which means the donor may name anyone else who is not considered as legal heir under Faraid to receive one-third of his wealth upon his death. If he wants to give more than one-third, consent from all legal heirs must be acquired. In the event of the named beneficiary predeceased the donor, this portion shall be distributed under Faraid if no replacement has been made. So, yang pertama adalah 2/3, yang kedua adalah 1/3. So ini adalah suggestion yang pertama. Second one is appointment of the trustee. The trustee in Hibah Trust shall be an entity with knowledge and expertise in Islamic estate planning, either individual or organisation. It is possible for a legal heir to be appointed as a trustee in Hibah Trust. As a legal heir may also be appointed as a protector to supervise the management and distribution of the deceased wealth undertaken by the appointed third-party trustee to ensure that the rights of other legal heirs are protected. However, he must be liable for his decisions and must act independent of his personal desires and interests. So, appointment of pelantikan trustee tu mestilah adalah orang yang expertise dalam Islami dalam bidang perhartaan Islam, sama ada ia adalah individu ataupun organisasi. Ini bagi memastikan dia boleh menasihati ataupun menguruskan harta-harta hibah itu dengan adil tanpa mengabaikan pewaris-pewaris yang lain. Okay. And the second one and the last one is BNM guideline. The whole structure of Hibah Amanah in its current form must Syariah compliant, which means semua yang berkaitan dengan berkaitan dengan Hibah Amanah ni mestilah mengikut Syariah compliance. So being an Islamic financial product, it is essential for Hibah Amanah to comply with all legislation and guidelines related to its space, especially the Islamic Financial Service Act and the numerous BNM guidelines. So sebelum ni setelah kita ceritakan bahawa tak ada pun guideline tentang hibah amanah dalam Bank Negara Malaysia punya guideline. So perlunya ada guideline BNM supaya apa yang sedang berlaku, apa pelaksanaan yang sedang berlaku itu adalah mengikut syariah compliance dan tidak membawa risiko terhadap ketidakadilan terhadap waris-waris yang lain.
So, for the conclusion, it is essential that trust hibah is not being used as a backdoor method to deny the legal heirs their property rights and maintenance. Although the existence of trust hibah under civil law is recognized as legal as one of the property planning instruments in Malaysia, but for Muslims, this method can be considered invalid because it is not in accordance with the law of hibah, will, trust and Islamic inheritance. So, we hope with the suggestion that we had given, it can overcome this problem. It is vital to have a clear legislation on the matter to ensure an accurate, legally defined position in relation to the rights and responsibilities of the parties involved, together with the necessary guidelines and limitation on trust hibah. The innovative Islamic products should be welcomed but cautiously implemented. Thank you.